I'm criminal defense attorney Aaron J. Boria, and today is part 2 of my court hearing videos. So part 1 was about arraignment at the 35th District Court in Plymouth, and this is going to be part 2, which is going to be about your pretrial if you've been charged with a crime out of the 35th District Court. So that could include Canton, Northville, Plymouth, the townships and cities within those jurisdictions. Now, this procedure legally is going to be the same in every court as far as when the hearings, in the way they occur and what happens. Now, procedurally, what actually happens at them or when you have them, that could be a little different from court to court. So this is specific to the 35th District. But for the most part, you can bet that if you're in Michigan, this is pretty much how it's going to happen. So anyway, at your pretrial, that's going to be either after your arraignment, or sometimes it can even be on the same day. This is where your lawyer will go and talk to the prosecution. Now, in any criminal case, the burden is on the prosecution to prove the crime against you. In other words, let's say that you've been charged with drinking and driving. The prosecution would have to present evidence that you were operating a motor vehicle on a public roadway or a road generally accessible to the public, and that you would consume some kind of alcohol or liquor, that you submitted to a chemical test, the test was reliable, and you were over the legal limit. They have to prove all of that. You don't have to prove a thing. So, you go to the pretrial, your lawyer talks to the prosecution, and with the discovery that hopefully your attorney's acquired by then, that's the police report, video, things like that, they talk about the case, whether or not the prosecution can meet their burden. Now, in many cases that I have, where the prosecution can meet their burden, and this is true for whether it's the 35th District Court or it's any other court in Michigan, even when the prosecution can meet their burden, I'm able to get some kind of reduction and in even some cases a dismissal. Now, in other cases where the prosecution cannot meet their burden, that may result in a dismissal, or it could even result in having to go to trial if there's just a factual dispute. In some cases, you're just going to disagree over the facts, meaning that you have a factual dispute. A great example of a factual dispute is a self-defense case. Many times in a self-defense case, what happens is one person gets charged with assault and battery, and that same person is claiming, yeah, I did hit the person accusing me of a crime, except that I was defending myself, so I was in the right. Well, your case doesn't get dismissed just because you claim that you were acting in self-defense. You have to present that defense to a jury, and then the jury has to agree with you. It's a factual dispute. Were you assaulting the person, or were you acting in self-defense? So that's a factual dispute. That's something that probably won't get dismissed, and it's something that you're probably not going to want to plead guilty to, so it goes to trial. So at the pretrial, you can either enter a plea to the charged offense or to the reduced charged offense if that's on the table for you. You can set the matter for a trial, or you can also set the matter for an evidentiary hearing or a motion. That is where your lawyer is challenging a legal issue. A legal issue in a DUI would be the basis for pulling the person over. A jury does not get to decide that. The judge does, so it is a legal issue, and the case could potentially be dismissed on that. After you have your pretrial, you will either proceed to sentencing hearing, which could come on the same day or later if you pled guilty to the charge or to a reduced offense. You could head to the evidentiary hearing or the motion hearing if you're challenging a legal issue, and then finally you could head to a trial if you are going to argue over the facts of the case. And then, of course, if you get a dismissal, then you leave the court and you don't come back. If you've been charged with a crime, give me a call. I'm criminal defense attorney Aaron J. Boria. I fight for my clients. I know the law, and I get results that other attorneys simply cannot. Call me today, 734-453-7806, or shoot me an email at borialaw@gmail.com. I am happy to fight for you.